Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. On June 3rd, the new Canadian government tabled Bill C-2 in Parliament. It's called An Act Respecting Certain Measures Relating to the Security of the Border Between Canada and the United States and Respecting Other Related Security Measures, but with the short title of the Strong Borders Act. Once again, following the footsteps of past conservative and liberal governments, it contains a Trojan horse that revives what has come to be known as lawful access. I'm really getting tired of these sorts of bills. In my last episode, I discussed Part 14 of the bill, which creates new law enforcement authorities to get customer information, either without a warrant or court order, or with an order but based on a very low standard. In this episode, I'll go over Part 15 of the bill, which creates a standalone Supporting Authorized Access to Information Act. The government says this is simply to make sure that electronic service providers have the capacity and capability to share information with authorized persons. I think it goes beyond this. It's similar to Bill C-26 from the past Parliament, as it allows the government to dictate what technologies electronic service providers have to use. Now this time, it's to create the capability for law enforcement to plug into service provider systems. Now, throughout this discussion, I can't help but be reminded that the US has had something similar in their laws, and it mandated intercept capabilities that ultimately ended up being used by Chinese hackers to get access to data. The so-called Salt Typhoon hacking incident, attributed to a Chinese state-sponsored advanced persistent threat actor, came to light in late 2024 with revelations that the group had extensively compromised the computer systems of multiple major US telecommunications companies. The stolen information included call and text message metadata, and in some high-profile instances, even audio recordings of phone calls belonging to government officials and political figures. A critical factor that facilitated the Salt Typhoon incident was the very infrastructure put in place to comply with something called the Communications Assistance for Law Enforcement Act, or CALIA. Enacted in 1994, CALIA mandates that telecommunications providers build lawful intercept capabilities into their networks to allow law enforcement and intelligence agencies to conduct court-authorized wiretaps. While intended for legitimate, authorized surveillance, these mandated backdoors created inherent vulnerabilities within the telecom networks. Salt Typhoon exploited these CALIA-mandated systems, effectively turning the tools designed for lawful access into pathways for unauthorized espionage. And this is what's coming to Canada. The Supporting Authorized Access to Information Act creates a framework in which the Government of Canada can require electronic service providers to facilitate law enforcement and intelligence services access to data and information. So much of its scope, however, is left to the regulations. Now, the sweep of what entities can be in scope of the bill is very broad by regulating electronic service providers. And this is from the definitions. Electronic service provider means a person that individually or part of a group provides an electronic service, including for the purposes of enabling communications, and that A, provides the service to persons in Canada, or B, carries on all or part of its business activities in Canada. And electronic service is defined as a service or a feature of a service that involves the creation, recording, storage, processing, transmission, reception, emission, or making available of information in electronic, digital, or any other tangible form by electronic, digital, magnetic, optical, biometric, acoustic, or other technological means, or a combination of any such means. Wow, this is extremely broad. It would likely capture almost all communication service providers that provide any service to Canadians. It likely covers VPN or virtual private network providers, as they provide a service that involves the transmission of information. This would also scope in text messages, emails, phone calls, voice over IP calls, and video calls. Now, the Act specifically will target what are called core providers, who are electronic service providers belonging to a class of electronic service providers set out in the schedule. Now, in the version of the bill tabled at first reading in Parliament, the schedule is blank. I guess it's kind of TBD, to be determined. But I expect it will be all the major telcos and internet service providers in Canada. It may also include the significant messaging providers like Apple, WhatsApp, Microsoft Teams, Zoom, email providers like Microsoft, Apple, and Google. Now, it is very broad in its possible scope. The Act in Section 5, Sub 2 empowers the government to create regulations placing obligations on core providers The regulations can provide for A, the development, implementation, assessment, testing, and maintenance of operational and technical capabilities, including capabilities related to extracting and organizing information that is authorized to be accessed, and to providing access to such information to authorized persons. B, the installation, use, operation, management, assessment, testing, and maintenance of any device, equipment, or other thing that may enable an authorized person to access information. And C, notices to be given to the minister or other persons, including with respect to any capability referred to in paragraph A and any device, equipment, or other thing referred to in paragraph B. Importantly, a core provider is not required to comply with the regulation if compliance with that provision would require the provider to introduce a systemic vulnerability in electronic protections. And those electronic protections are defined as authentication, encryption, and any other prescribed type of data protection that is related to that service, or prevent the provider from rectifying such a vulnerability. This would permit a regulated core provider to refuse to install a backdoor or compromise encryption if that would create a systemic vulnerability. Core providers can apply for an exemption for a specified period of time in order to have time to come into compliance. Under Section 7, the minister is able to issue orders to any electronic service provider, regardless of whether they're a core provider, along the lines of the regulations authorized under Section 5, Sub 2, for a specified period of time. But in making the order, the minister must consider A, the benefits of the order to the administration of justice, in particular to investigations under the Criminal Code and to the performance and duties and functions under the Canadian Security Intelligence Service Act. B, whether complying with the order would be feasible for the electronic service provider. C, the costs to be incurred by the electronic service provider to ensure compliance with the order. D, the potential impact of the order on the persons to whom the electronic service provider provides services. And E, any other factor that the minister considers relevant. Now, the minister, in their discretion, may provide compensation to offset some of the costs incurred that are referred to in paragraph C. Now, similar to compliance with regulations, an electronic service provider is not required to comply with a portion of an order that would require the provider to introduce a systemic vulnerability in electronic protections related to that service or prevent the provider from rectifying such a vulnerability. The minister is required to permit affected electronic service providers to make representations prior to issuing an order under Section 7. The Act contains a very broad and, in my view, problematic obligation on all electronic service providers to provide all reasonable assistance to a range of persons to permit the assessment or testing of any device, equipment, or other thing that may enable an authorized person to access information. The list of persons authorized to make this demand include the minister, CSIS employees, police officers, and civilian employees of a police force. But there's no threshold, there's no limitation on this power. For example, there's no requirement for approval from the minister or any other senior person. It does not have to be reasonably necessary for any of the purposes related to the Act. You could have a lineup of people from every municipal police department out the door of an electronic service provider, and the electronic service provider has to provide this unlimited and unbounded assistance. The Act then contains at Section 15 very broad prohibitions on disclosures by electronic service providers, including whether one is subject to an order, the contents of an order, information relied upon by the minister in making the order, representations made by the electronic service provider or the minister, even the fact that representations were made. This is ridiculous. It may make sense to give the minister the power to issue gag orders from time to time where they're of the view, reasonably, that disclosure of the information would compromise law enforcement or national security. In this country, secrecy should be the exception and should have to be justified. Secrecy should not be the default, particularly with respect to services that we use every day and with respect to impact on our civil liberties. This is so prone to overreach and possible abuse, and all of it takes place in the shadows, outside of view. It is very problematic, in my view, that an electronic service provider is prohibited from disclosing information related to a systemic vulnerability or potential systemic vulnerability in electronic protections employed by that electronic service provider. Let's break that down. This would mean that if any electronic service provider were to discover a vulnerability in their system, that service provider would be prohibited by Canadian law from disclosing it to anyone. This may include a prohibition on disclosures to customers who may have been affected by a past or current vulnerability, or even that company's own contractors who carry out security audits on its systems. For example, if a telco discovers a vulnerability in a router, they will tell the manufacturer of the router and various organizations that work diligently to make sure that the entire cybersecurity community can identify and fix vulnerabilities. But if a telco finds a vulnerability in a system used by all Canadian telcos, which is even more likely because the government will get to dictate what systems telcos use, they can't alert the other telcos about that vulnerability. In my view, paragraph G is actively harmful to Canadians and will be a huge boon for the bad guys who look for and exploit these vulnerabilities. It really, really has to go. It's worth noting that the parameters of these prohibitions on disclosure can be subject to regulations made pursuant to Section 17 of the Act. Yeah, and those regulations could make it even worse. But under Section 16, if an electronic service provider is to seek an application for judicial review of any order or decision under the Act, it's prohibited from doing so unless it gives 15 days advance written notice to the minister, along with a copy of the notice of application. Under Section 17, the government can make regulations respecting confidentiality and security requirements for electronic service providers, and persons acting on their behalf must comply. Specifically, it authorizes the creation of regulations, A, respecting the disclosure of information referred to in Section 15, B, establishing rules of procedure for the protection of information referred to in Section 15 in administrative or judicial proceedings, C, respecting requirements related to employees of electronic service providers and other persons whose services may be engaged by electronic service providers, including with respect to their security clearance and location, and D, respecting security requirements with respect to the facilities and premises of electronic service providers. Again, this is extremely broad. It's not limited to confidentiality and security measures that are reasonably required related to the purposes of the Act. Remember, electronic service provider is broad enough to include service providers completely and entirely outside of Canada. It potentially includes requirements for all an ESP's facilities, regardless of location, and paragraph C even permits regulations regarding where those facilities can be located and security clearances for those employees. Now, to me, this is clear overreach. None of it's limited to protecting the security of lawful intercept and information gathering capabilities dictated in the Act. Now let's talk about enforcement and administration. The Act gives the minister authority to designate persons or classes of persons to administer and enforce the Act. These designated persons are given vast powers to enter, under Section 19, any place other than a dwelling to verify compliance or to prevent non-compliance with the Act. Within such a place, once they're in there, they are authorized to A, examine anything found in the place, including any document or electronic data. B, make copies of any document or electronic data that is found in the place, or make extracts from the document or electronic data. C, remove any document found in the place for examination or copying. D, use or cause to be used any computer or data processing system at the place to examine or copy electronic data. And E, use or cause to be used any copying equipment at the place to make copies of any document. The Act places an obligation on every owner of a place, the person in charge of the place, and everyone in the place to give all assistance that is reasonably required by the designated person, including providing any document or electronic data they may reasonably require. In addition, in Section 19 sub 6, a designated person can bring anyone with them to assist. Now, this is not specifically limited to places in Canada, but likely cannot be enforced outside of Canada. But again, this is completely without limits. The designated person can say, I want your entire customer database, and the ESP ostensibly needs to comply. Even more, it would be illegal for an employee there to not assist with this outrageous demand. The Act also provides for orders. So under Section 21, a designated person can order an electronic service provider to conduct an internal audit of its practices, documents, and electronic data to determine whether it is in compliance with any provisions of this Act or the regulations. A copy of the audit must be provided to the designated person, and if the audit uncovers any non-compliance, it must specify the non-compliance and measures taken or to be taken to comply with the relevant provision or the order. Now, the Act at Section 23 gives the designated person even broader order-making powers. If they believe on reasonable grounds that there is or likely to be a contravention of the Act or regulations, they can issue a written mandatory order requiring an electronic service provider to A, stop doing something that is or is likely to be in contravention of that provision or cause it to be stopped, or B, take any measure that is necessary to comply with the requirements of that provision or mitigate the effects of noncompliance. Now, these orders are subject to review by the minister on request of the electronic service provider. And unless otherwise ordered by the minister, the order issued by the designated person must be complied with in the meantime. Now, no Canadian regulatory scheme would be complete without administrative monetary penalties. And let's throw in some offences. So the Act, beginning at Section 27, provides for a full administrative monetary penalty regime that is intended to promote compliance with this Act and not punish. The punishment part is taken care of in Section 40, which creates a whole bunch of offences. So if a contravention results in administrative monetary penalty, the penalty can be up to 250,000 Canadian. And if a violation continues more than 1 day, each day constitutes an additional violation. The due diligence defense is available as are common law defenses. But people should note the Act provides for liability also by corporate directors, officers, or agents or mandataries who directed, authorized, assented to, acquiesced in, or participated in the commission of the violation. Now, a notice of violation will set out the amount of the administrative monetary penalty, which can just be paid. And if you pay it, that amounts to an admission of the violation. Alternatively, the alleged violator can enter into a compliance agreement with the minister, essentially a consent decree, or can request a review by the minister of the acts or omissions that constitute the alleged violation or the amount of the penalty. In a review by the minister for a violation, the evidentiary standard is balance of probabilities, and there's no prescribed appeal from the minister's decision. Now, I would think that judicial review would likely be available in the Federal Court of Canada from such a decision. But in addition to AMPs, violations can also be penal offences, which are summary conviction offences with a maximum fine of $500,000 Canadian. Again, if a violation continues on more than 1 day, each day constitutes an additional violation. As with AMPs, due diligence is a defense, and officers, directors can also be convicted if they directed, authorized, assented to, acquiesced in, or participated in the commission of the offense. It's also an offense to obstruct or make a false or misleading statement to a person authorized to assess or test any device, equipment, or other thing, or a designated enforcement person. In a nutshell, this part of the bill has enormous impacts on electronic service providers globally and represents a huge overreach with enormous power and discretion given to the minister and designated persons. It has the potential to introduce significant vulnerabilities into the systems we use every day for our most private communications, and also may completely upend the practice of information sharing that is the foundation for keeping the internet safe and secure from cybersecurity risks. This supporting authorized access to information should be taken out of Bill C2 so it can get the attention, discussion, and scrutiny it deserves. I'm really afraid that it'll be jammed through Parliament under the guise of strengthening our border to appease the current U.S. government. And we know that once governments get powers, they never surrender them. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.